Board this and welcome everyone. Again, my name is Kelly Nevins and I am the CEO of the Women's Fund of Rhode Island. And tonight we are going to run a program called Women's Financial Empowerment, Trust and Estate Planning. And what I would like to do first, before I show Claire's presentation, is show mine, which is just a basic general information piece about why it's important for women to have wills. And I would do this if my computer was working correctly. Give me just a second here. Let me see what's going on. Do you just see my PowerPoint presentation now? There's no...
Ellie, we see your background as well, so it's not taking up the full screen.
Okay, thank you.
That's better. Yeah.
Awesome. Okay. So actually, I think most of you who are here with us tonight know about the Women's Fund and what we do, but just as a refresher, we're a nonprofit organization based in Providence. We're a statewide organization, and our mission is to invest in women and girls through research, advocacy, grant making, and strategic partnerships designed to achieve gender equity through systemic change. And so tonight we look at this as sort of sharing some of the research that we know about the status of women and girls and informing people about how they best can invest in themselves. Just most of you know that there is a gender wage gap as well as a gender wealth gap. The current gender wage gap is about 82 cents across all women compared to white men. Although as you start breaking it down by different races and ethnicities, you start to see that that wage gap gets broader and broader. So for Asian women generally, which is a really big category, 77 cents on the dollar, Black women, 59 cents on the dollar, and actually Hispanic and Latina women, it's less than 50 cents on the dollar these days. Because of the wage gap, there is also a wealth gap. And so what we know is that single Black women have a median wealth of $200 compared to $15,640 on average for a white woman. But when you compare that to a white man, they've got nearly double that in terms of wealth accumulated over their lifetime. And in addition, women tend to be weighed down by debt by 177% over what men owe. They are likely to have all different types of debt. So it could be credit card debt, school debt, mortgages, cars, et cetera, et cetera. And at the same time, women, 2/3 of us are the sole or primary breadwinners for our families, which means not only do we own less, but we're spreading what we owe, what we own and what we make over a broader group of people. And because of COVID, the losses are getting bigger and bigger over time. The last sort of bad piece of bad news that I'd like to share here is that women, when they are the sole homeowners, have 17% lower market value in their homes compared to men. So that's tough. And then when we look at that wage loss over a lifetime, a 40-year career, what we see is that white women compared to white men have, they make less than almost $500,000 worth in over a 40-year career. A Latina woman is losing $1.2 million over the course of her lifetime due to that wage and wealth gap. And unfortunately, what we know from research is that wage and wealth gap begins right when women get out of school. So presumably, you know, before there are any types of responsibilities that have been added onto us, we haven't yet built our families, and we're taking similar jobs to men. We right from the get-go are starting to earn less. And so fixing the wage loss and fixing the wealth loss over time when we think, or adjusting for it, is really important for us. It means more money for our families and for the economy. So there are 6 drivers that contribute to the wealth gap, and again, particularly for women of color. First of all, there's this legacy of racial and sexual discrimination in credit and lending markets. Women of color in particular, especially, historically have had a harder time getting approved for credit, including business loans, home loans, leading to predatory lender practices like, payday lenders, that kind of thing. Women have been denied fair access to affordable mortgage products and targeted with risky products that have included unaffordable adjustable rate mortgages. And then over time, when we think about employer-based retirement and savings plans, because women tend to hold more part-time jobs and hold lower level full-time jobs, they don't get quite as much access to employer-based retirement and savings plans. And then when you add to it that sometimes we just don't know enough about how do we make ourselves financially empowered, all of this adds up. And so at the end of the day, this means that we have to really think about how do we change things so that we can make sure that we're taking care of ourselves in our older age, and then also for our families after we pass away. So what can you do for yourself based on all of this really awful information that I've shared? First of all, women aren't necessarily known for negotiation in the workplace, and it is actually really, really incumbent on you that you ask for the pay and the promotion that you deserve. So I do a salary negotiation workshop if you ever want to sign up for something like that. But it's really important to be benchmarking what you make against others in the industry who are doing what you do in the area that you do it, and asking and making sure that you're getting paid appropriately for the work that you're doing. Women in particular need to plan for career interruptions, meaning, if you think at some point you might want to raise a family, being able to plan appropriate for those times when you may need to take family leave or even sick leave is really important. Many of us right now are caught in the sandwich generation where we have kids, but we also have older parents that we need to be taking care of as well, and may need to take time off to care for our loved ones as they get older. Really thinking clearly about how the life choices that you make are impacting your pay today. And this is hard for me because, of course, pretty much my entire career has been in the nonprofit sector. And in the nonprofit sector, we're known not to pay as well as the for-profit sector. And sometimes we don't get all the benefits that the for-profit sector gets. It's not that you shouldn't take lower paying jobs, and it's not that you shouldn't do the work that you're doing, but you need to plan and understand how the choices that you make today and yesterday, what kind of long-term effect that they're going to have on you financially. And then also to know, this probably doesn't come as a surprise, but women live longer than men. So the money that we have been able to save and accumulate over time, we need to stretch it over longer periods of time because we live longer than men. And then finally, this would not be a Women's Fund presentation if I didn't talk about how we advocate at the state and the national level for policies that make sure that we are addressing gender equity. And that includes last year helping to pass the Fair Pay Act as an example, helping to pass important laws like paid sick and safe leave, paid family leave, which we need to expand in Rhode Island. All of these things are things that tie into the wage and wealth gap for women. And so please, if you have any interest in joining our advocacy efforts, we would ask you to join us. But that, my friends, is the basic background bad news. And here tonight, I'm pleased to introduce again Claire Carrabba. She's an attorney at Day Pitney, who is going to talk about what can you do and how can you address some of these things by some financial planning that includes wills and estate planning. And so I'm going to turn this over to Claire. If I can figure out how to start the slide presentation.
Thanks, Kelly. And I'll go through a couple of introductory remarks while you get the slideshow going. As Kelly mentioned, I'm an attorney. I've been practicing in the area of trust and estate. So as I like to jokingly say, all things death, dying, and taxes for about 9 years now. A couple of disclaimers. So the first thing is Kelly mentioned, this isn't legal advice. I am giving a general presentation. You can feel free to ask questions. I will answer them, but I am obligated to tell you that I'm not your lawyer. It's not legal advice. I have to get that out of the way. The second caveat is a little more personal to me. I have a sick kid at home right now who is a bit of an agent of chaos to begin with. And when he's sick, sometimes he's a little harder to contain. So if he bursts in, I'm just going to apologize in advance. He can open every door in this house. And then the third thing, as Kelly mentioned, feel free to ask questions. I know that Zoom has features where you can raise hands or do reactions. I'll respond to any reactions that pop up. You can ask questions in the chat, you can interrupt me, or you can save your question until the end. I've done this presentation before. I do get some hypotheticals, which are generally personal situations. Happy to talk those through as well. And if you ask a question that I'm going to address a little bit later in the presentation, I'll tell you that too. Kelly has been kind enough to offer to manage the slides for me since I was having some technical difficulties with my computer. So thank you in advance for that, Kelly. And if you want to go right ahead to the first slide, we'll dive in. So estate planning is important for many reasons. The first and probably most well-known reason is to ensure that your property goes where you want it to go. The people that you want to benefit from your property should get your property. And that's not always the case under the law's default. Every state has default laws that say, if I don't do anything, if I don't name any beneficiaries, if I don't do a will, here's where my property is going. And again, it doesn't always line up with the people you actually want to benefit. Another thing that people don't necessarily consider is estate planning helps you plan for incapacity during your lifetime. There's a couple of documents you can execute that will prevent you from having to move forward with a guardianship with the court. That's a big deal, doing a guardianship. This allows you to say, I know who I want to make my decisions for me. I know who I want in charge. I'm going to name them. I'm empowered to do it. Estate planning also minimizes costs. There's ways to minimize estate taxes, administration, expenses, court costs, and fees. If you set everything up in advance, you can often save some money for your ultimate beneficiaries when you pass, and save some money if you're incapacitated. And estate planning, for these reasons, estate planning is important for everyone. Next slide, please, Kelly. Thank you. So a lot of people like to talk about the estate tax system, particularly people in positions of very high wealth like to argue about it in Congress, but I'll give you the rundown here. In 2022, the federal estate and gift tax exemption is $12.06 million. I believe it's going to go up to about $12.5 million next year. Top marginal rate of 40%. In Rhode Island, it's just about between 1.6 and 1.7. Top marginal rate of 16%, and there's no gift tax. So there is if you give away more than 12.06 million during your lifetime, you can incur a gift tax. I'm not going to talk too much about that. So generally, you can avoid this tax through distributions to your spouse and to charitable organizations. So you could give a charity $50 million. The government doesn't care because it's all deductible. Next slide, please. Thank you. So a lot of people also talk about probate. What is probate? Probate is the process by which a court oversees the distribution of your estate after your death. So it can involve extra expense and delay, and the probate court has jurisdiction only over property in your name alone. It doesn't affect property that's held with a joint owner. It doesn't affect property that has a beneficiary designation or a transfer and death designation. And it doesn't affect property that's held in a trust. A kind of a quick rundown on probate is if I had an account that was just in my name, let's say it's a Bank of America Citizens account that just says, Claire Carrabba on it, and I say, I want my spouse to be in charge after my death. If I don't do anything, he can't go to Bank of America and get it. The court has to recognize, yes, okay, Claire did in fact pass away. She had a valid will, and it named her spouse as the person who's in charge, and the court verifies that, and then you go to the bank with that information. So that's basically probate in a nutshell. And a lot of people are concerned about it. It can involve extra expense, but it's not as disastrous as sometimes people think, especially in Rhode Island. There are some states where it is a little bit tougher. Next slide, please. Thank you. So typically, if clients come into my office and they say, I want to do my estate plan, their typical documents include a healthcare power of attorney, HIPAA release, durable power of attorney, a will, and then sometimes a revocable trust. Next slide, please. Thank you. So the healthcare power of attorney, this is a document that is only effective during your lifetime. I like to say when you die, it dies. But this is the person who makes your healthcare decisions if you're not able to. So this is in the case of incapacity, let's say of Alzheimer's or or some sort of dementia, and you can't make your decisions. The person you name in this document is going to be making your healthcare decisions. What medications to give, what kind of therapies to do. The person you name your healthcare power of attorney also is the person that, let's say, a surgeon goes to if you're under anesthesia and there's a decision that needs to be made and you can't do it because you're in surgery. That's the person who's going to make those decisions. You may also see a living will. Some states recognize them, some states don't. Rhode Island, typically, it's more of a designation of wishes as opposed to a binding of document. And that's the document that says pull the plug, don't pull the plug, withhold nutrition, keep me comfortable, things like that. And this is one document that will help avoid a guardianship because you already have someone in place to make your decisions. And any sort of medical facilities will go to this person named in the healthcare power of attorney, as opposed to saying you don't have anybody lined up. You need a court order, and that's what a guardianship is. It's going to court to say I need a court order to take care of Claire's healthcare decisions. And again, it ends at your death. Logistically, copies of these documents should go to healthcare providers. A lot of them have online systems. You get them scanned in one place. They show up in every other place because I think all the hospitals seem to be owned by the same company. HIPAA release. HIPAA release authorizes certain individuals to access your medical information. So in addition to naming an agent and a healthcare power of attorney, you can also name, let's say, all three of your children to access health information so they can make decisions together as opposed to just having the one person have access. Again, same thing, copies should be kept through their medical records. In some places, you'll see this as part of the healthcare power of attorney. You'll see one big document that has, I name this person as my agent to make my healthcare decisions, and these other people are named to access my medical records, x-rays, blood work, things like that. Next slide. Awesome. Thanks, Kelly. A durable power of attorney, it's a similar document, but the agent you name in your durable power of attorney actually deals with your finances instead of your healthcare decisions. So it's typically a broad document because we want to cover everything. We don't want to have that durable power of attorney not work when we need it to work. This is the other document that helps avoid a guardianship. Again, you have someone named to make your healthcare decisions, you have someone named to make your financial decisions. So we don't need to go to court for a guardian. Next slide, please. Will. So the will is only effective at death. And this directs the administration and distribution of your probate assets. As I mentioned before, those are assets in your name alone. And in general, you can give your assets to anybody you want. It doesn't have to be family members. It doesn't even have to be humans. You can name spouses, children, family, friends, charitable organizations, and believe it or not, there's even a concept called a pet trust. So you can leave your property to benefit your pets. I've only seen it done once, but some people, there are a lot of cases, famous cases out there of millionaires leaving their all of their estates to benefit their pets. A will can also include trust provisions for minor beneficiaries or special needs beneficiaries. There are some instances where rather than having an individual receive assets outright, you might want them held in trust. Good example of that, you've got little kids. You certainly aren't going to hand a check to a 3.5-year-old. I'm not going to do it to my 3.5-year-old. Or someone who has special needs and is on government assistance that is maybe asset or income determined, you don't necessarily want to hand them a check either because it could interfere with government benefits. Some people choose, in addition to a will, to create a revocable trust. And in that case, the will would be what we call a pour-over will. It says, I want all of my assets to go to a trust. Next slide, please. The will also names the following fiduciaries, and fiduciary is a fancy term for someone who's managing property or decisions on behalf of another person. So the big one is your executor. That's the person who actually administers your will. They're the person who's going to make sure all of your debts are paid, pay expenses, taxes, and they're going to marshal your assets, make sure they've got everything, and distribute them where they need to go. A lot of people will name a family member, but you can also name a bank or a trust company, a CPA, a friend. You can name almost anyone you want there. Another big person, another big fiduciary you would name in your will is a guardian. So if you have minor children, this is where you, as the parent, nominate a guardian for your minor children in case, you know, in the unlikely event that you predecease your children. Awesome, thank you. Revocable, or sometimes called a living trust. This is a document, this is an instrument that's established during your lifetime. It can be revoked or amended by you at any time. And I do want to note here, all of the documents I've spoken about can be updated, changed, amended at any time. I've had some clients who change their documents every year. I've had some clients come back to me within a month or two and say, things have changed. I need to name a new person in my durable power of attorney. I need to change this bequest. So it's all amendable and revocable during your lifetime as long as you're competent. So during your lifetime, you would typically serve as a trustee, and assets held by the revocable trust are managed by you and used for your benefit. Sometimes I refer to a revocable or living trust as your alter ego. It's simply your assets are held in this revocable trust. You're in charge of it. Any income is reported on your own income tax return, but it's just held in this kind of separate bucket. You can name family members, individuals, banks, trust companies to act as successor trustees, same as executors. And then at your death, the revocable trust provides where your property would go. And sometimes assets might already be in there. You can put assets in there during your lifetime. Sometimes it's the will that says, I want all of my assets to flow through this revocable trust. Next slide, please. So there's a couple of reasons people like to use revocable trusts as opposed to simply a will. Revocable trusts are great for avoiding that probate process we talked about. If you don't want to deal with the court at all, you can transfer all of your assets in your individual name into your living trust while you're living. And then at your passing, everything's already transferred over. And the successor trustee is on deck to deal with everything. You don't have to get permission from the court. You don't have to file anything. You don't have to get a fancy stamped piece of paper to bring to the bank. Everything's in the trust, and the trustee is already authorized to deal with your property. Probate avoidance also allows you to keep things private. Wills in Rhode Island, and I think almost every state, are public documents. So let's say I pass away tomorrow. When my will is filed with the probate court, anybody can go down to that probate court and say, I'd like to see the file on the estate of Claire Carrabba. They can see what you've named in your will. They can see where property is going. Eventually, they can see all the property that was in your name alone. They know how much is in there. So some people prefer to do a revocable trust right off the bat for privacy reasons and probate avoidance. Asset management, protection for spouse, children, other beneficiaries. So it allows you to set it up right away. You can fund certain trusts for individuals. We talked about special needs, beneficiaries, children, and you can, I'm not sure I understand. Sorry, my Siri just started talking to me. Said it's not, I'm not sure I understand. So hopefully you understand, and that's just my watch. So you can, that's where you can name your beneficiaries as well. I'd say that biggest reason people will use is revocable trust, which are, it's a separate legal document, so there is an upfront cost to draft it. I think the biggest reason people will choose to spend that money is for estate tax planning. There are ways to set up the trust so that you can maximize the amount of estate tax exemption you have and maximize the amount that passes to your beneficiary. And I mentioned privacy already of appropriate avoidance. I do want to note that revocable trusts are not used in connection with Medicaid planning. Medicaid planning is when you or a loved one is entering a nursing home and you want to shield some of your assets from having to pay for that nursing home. That is a very different, PowerPoint presentation. So revocable trust generally not used for that. So other ways that property will pass at your death are by beneficiary designation. So these have nothing to do with probate. These have nothing to do with your trust. And certain assets are more likely than others to pass by beneficiary designation. Life insurance, you can name a beneficiary, that person will inherit your life insurance proceeds when you pass. You simply give them a death certificate and maybe fill out a form. Retirement plans. I'm sure if you work and have a retirement plan through your employer, I'm sure one of the first forms they handed you was, here's the beneficiary designation, who's your beneficiary. There are certain federal rules that require you to name a spouse on some of them unless the spouse waives it. And then accounts with a POD or a TOD beneficiary named. Typically, those are bank accounts, investment accounts. And what all of this means is at your death, the person named as the beneficiary will simply go to the institution with a death certificate and say, I'm Claire. I'm named as the beneficiary of my spouse's life insurance, and they give you a check for the proceeds, or they establish an inherited IRA for the retirement account. And it's really, really, really important to review these beneficiary designations on a regular basis, especially after you have children or changing your marital status. I have a situation in my office right now where I don't know when this happened. We have a client who passed away. She named her grandchildren as the beneficiary of her retirement account, which is in and of itself is not a problem. Nothing wrong with naming other beneficiaries. Then, she does have a spouse and children, but she wanted to benefit her grandchildren. However, those grandchildren are minors, and the custodian of the retirement account won't allow us to pay out those proceeds or turn them into inherited retirement plans without going to court for a guardianship for the minors. We can't pay it to the parents. We can't open up a special bank account for it. We've got to go to court. So it's really, really important to check out your beneficiary designation. Did you perhaps name your husband and then your children, and maybe your husband or wife has passed away, and you've got young children? Just check those retirement accounts, because people name them and then they forget who they named. Next slide, please. Joint ownership. This is another big one. So if an account or property is held as joint with rights of survivorship, that will pass to the surviving owner at your death. Sometimes people don't realize that. A lot of banks, especially, I've seen this a lot with elderly people, the banks will really encourage people to name a joint owner, and they'll say, listen, this allows someone else to write checks for you. You can have your daughter access the account and write checks and pay your bills if she's a joint owner. And that sounds really good, right? That sounds great. You don't have to worry about a durable power of attorney having access to your checking account. You don't have to worry about getting someone to help you with your check writing. I've got my daughter on there. What a lot of people don't realize is that that person inherits the property at death. And that might not be the person's intention. A lot of times, you've got, let's say you got 3 kids, one's kind of the responsible kid, and the parent says, listen, I'm gonna name my daughter. She's super responsible. She's gonna help me. And she knows what to do with the property. She'll deal with everything. And then at death, the daughter says, hey, I'm gonna join owner on all these. This is my money. And that's not necessarily what parent intended. Parent intended to benefit everybody equally. So it's important to think about who are your joint owners. Same thing, banks encourage it. You forget who you might have named when you opened the account, especially people who've opened an account a long, long time ago. Review them, check them, see who's named as your joint owner. Next slide, please. That's my basic presentation. I got through it pretty quickly because I didn't have a ton of questions yet, but I'm very, very willing to answer questions, whether they're kind of hypotheticals, if there are questions about any of the specific documents or topics I mentioned, or anything I didn't mention that you were hoping I would. Hi, Susanna.
Hi, Claire. Thanks for that presentation. That was really succinct and clear and awesome. Can you go over very briefly what happens in Rhode Island if you die without a will? How does your property pass? And then the second part of that question is it determined by where you live when you die, or is any of it determined by the state where your property is held, if that might be different than Rhode Island?
That's a really, really, really good question. So I'm gonna answer your question backwards. So the answer is yes to both those last questions. It's determined by where you live and where the property is. So if you're a Rhode Island resident, let's say you're a Rhode Island resident and you don't have any property outside of the state. Where your property goes depends on your family makeup. So, and again, this is just property in your name alone. Joint ownership, beneficiary designations, assets in a revocable trust, those will control. So these are those bank accounts that we talked about that just have your name on them. If you are married with no children, part of your property goes to your spouse and part of it goes to your other relatives. The same thing with children. If you've got children, part of it goes to the spouse and part of it goes to the children. The percentages are different depending on whether you have kids. And it's something like, I don't have it memorized off the top of my head. It's something like, if you've got kids, half of it goes to the spouse plus, and then the rest goes to the kids. And if you don't have kids, half of it goes to the spouse, and then an additional cash amount goes to the spouse, and then the rest will go to basically the other family members. There's also a carve out that says if there's a primary residence, the spouse can live in it, but she doesn't own it in the same way you would if you inherited it outright. Now, let's change the facts a little bit. Let's say you are a Rhode Island resident and you own Massachusetts real estate in your name alone. Massachusetts, and this is called what we call intestacy law, the intestacy statutes. So the Massachusetts intestacy statutes will control where that property goes. And that's a little bit different. I'll throw out an example. I had a client who her spouse did not have a will. It was a really tough situation, actually, for a lot of reasons, but her spouse did not have a will. And she did not get along with her brother-in-law, who was he inherited a lot of the property that she didn't realize would happen, but they also owned a house in Vermont. So as I mentioned, Rhode Island says, you get part of the property and everybody else gets the rest of the property. Rhode Island and Vermont law was different. Vermont law says if your married spouse gets it. So she got that Vermont property free and clear. She inherited that. We didn't have to worry about her in-laws, but the Rhode Island property was a little bit different. And every state is slightly different. So Massachusetts, for example, has a different scheme depending on whether you have a blended family or not. So if you've got kind of a nuclear family, spouse gets everything, but if you've got a blended family, things get split between, it doesn't matter who has stepkids, if either party has stepkids. Some goes to the spouse and some goes to the kids. It's a great question. Susan. Oh, you're on mute. Susan, you're on mute.
Thank you.
Thank
you, Claire. This has been really helpful. My husband and I are just updating our wills, so the timing is perfect. So one question is there a certain number of years that it's generally recommended to go to your lawyer, update your will? So that's one question. And then the second, since the last time we did our wills, we have 2 kids that are now majority age. So we had to update in terms of they no longer needed a guardian if we were both to pass. One thing our attorney is suggesting that we get a healthcare power of attorney, have our kids fill one out with our names on them in case they get in an accident somewhere or in a hospital somewhere. Is that something you recommend for kids who are adult kids who are not married or
these are also really good questions. So typically we say every 3 to 5 years, you want to at least revisit your documents. you don't necessarily need to update them, but you want to pull them out of whatever drawer or bookcase they are where you stuck them and hope you would never have to read the 20-page document the lawyer sent you and said you have to read. So you want to open it up. Do these provisions still work for the family situation I have? 2, do these provisions still work for the assets that I have? 20 years ago, your assets and your children were very different. So you want to at least review them every 3 to 5 years. You might not change anything. You might say, yeah, I did a great job 20 years ago. I don't need to do anything. And that's fine. We would typically recommend just refreshing your healthcare and durable power of attorney every 5 years, because one reason we recommend those ones be updated more frequently is sometimes if doctors or nurses see that they're really old, they get a little squirrely about honoring them. They want to see fresh documents, and same thing with banks. Banks and other financial institutions, they really scrutinize durable powers of attorney. Particularly in New York, I know we're not in New York, but New York banks and institutions hate them, and they will do anything they can not to honor them. So it's really important to, 1, review to freshen those healthcare documents so that the nurses and doctors can act with confidence when they need to, and 2, to update and refresh those durable powers of attorney to, 1, make things go a little bit more smoothly if you need to use them with banks or other financial institutions, and 2, we as attorneys are in touch with each other. We're monitoring kind of case law. So we see what happens when these documents are rejected, for example. We update them so that when we see situations that are problematic with the documents that we have, we update our forms. So what you get today has basically all of our collective expertise. And we as a trust and estates group of attorneys, collaborative group, we share everything, all of that stuff. So those are the 2 documents that I recommend actually updating every 5 years, even if they're the same, just because those provisions can change, and we want to make everything it's all about making your lives and your deaths easy, right? It's all about making everything easy. So that's why. With respect to the adult children, yep, a lot of people do that, and a lot of people do that when their kids go to college. Actually, they'll have their kids update, do a durable power of attorney and a healthcare power of attorney, so that the parents can correspond with the university health if they need to. If there is a if your kid gets sick at school and can't advocate for themselves, you have the healthcare power of attorney. And same thing with the durable power of attorney. College is super weird because the kids are adults, but you're probably still paying for them. So they get a little bit weird about financial records and stuff like that. So it's nice to have those documents on file with the university. And for everybody to have them in general, but it's nice for young adults to have them. All right, Marcella, I see you have your hand up.
Yes, let me lower it. Thank you, Claire, for all that information. I never knew that there was a difference in all these things. So my question is twofold, because I'm trying to learn not only for myself,
Yep.
Also I have, I don't have kids, but I have parents. I have older parents. And specifically, we were talking about the living will or just the power of attorney. So my question is not only for myself, but for my parents. This is something that's important. I'm my mom's only child, but she's also married, right? And so a power of attorney, I guess my question is, what is the best way to do it? What am I trying to ask in a concise way? I'm trying to figure out, how do I know who is a trusted person, or what signs I should look for humans that I'm going to, for a power of attorney for my parents, some like a living will. I guess, and I'll speak for myself. I'm a first generation. I have no one in my family who's ever thought of a will or anything like this. When you were talking about all this money, my friends and I were like, we don't have this kind of money. We're working towards it.
Not a lot of people have that kind of money.
Exactly.
That number is huge.
Correct, which is fine. And so I guess we're just trying to be proactive. And so I guess my question is, how do I, in going to find someone, what are the things that we should look for? Again, especially when it comes to attorneys, as someone who's not an attorney, how do we know, like, is someone charging you too much? Is there kind of shady? I would love something like that because I have no one else in my life that I would ask these questions to.
Those are good questions. So with respect to, I'm going to answer in two parts. So in terms of choosing someone to act as a fiduciary, who's going to be the person named in your healthcare power of attorney? Who's going to be the person named as your durable power of attorney? Who's your executor? Who's your trustee? So the healthcare power of attorney, you want to name someone who's going to be able to make tough healthcare decisions. That is not everybody. This is a really hard thing for a lot of people to think about, to talk about, to wrap their head about. I have family members and friends, and I talk to my friends and family about what I do all the time. They're very sick of it. So thank you all for being my captive audience for this evening. So some of them, they don't even want to think about end of life decisions or things like that. That might not be someone you want to name as your healthcare agent. You want to name someone who, you know, first of all, who knows your wishes. That's the most important thing. Is anybody you're naming, you want to have a nice conversation about them where you're both relaxed and you're in a good spot about, hey, I'm going to name you as my healthcare power of attorney. Here's what I want. I want extraordinary measures, or I don't want them. I don't want you to pull the plug. I want you to pull the plug after X, Y, and Z. I want you to keep me comfortable. Things like that. You want to make sure the person you're naming knows those wishes. They're very personal. There's not one right way to do this. That's the big thing. It's someone who's going to be calm and not just going to, for lack of a better term, lose it. We all know people, we all have different sets of skills. Some people are better in those situations, some people aren't. So you want to think about, okay, who's going to carry out my wishes and be calm and just get the things done that I need to get done. That's for the healthcare. The other ones, I like to call those ones kind of like paperwork jobs. So with respect to a durable power of attorney, an executor, and a trustee, you don't necessarily need to name someone who has experience doing it. A lot of people will name attorneys because they know, I do this day in, day out. That's fine. I'm good at it. I do it. It's easy for me as part of my job. But not everybody is a paperwork person. You want to name someone who is responsive. You want to name someone who will read their mail, get their mail, check their email, like those kind of things. And you want to name someone who's got good judgment. You want to know that the person you're naming knows their depths and their limitations. So if they don't have to do everything, right? Like, let's say you've got an investment account. I don't invest money. I don't know what to do with that. I don't know the market that well. If I'm named as a fiduciary, I can hire people to do investments or things like that. Or let's say I have a question, I don't understand what I'm reading, I'm going to ask somebody. You want to have someone with good judgment who's going to ask the right questions, get the right professionals, not going to try to do a tax return for the first time when it's your tax return, right? Like, you want to say, oh, I might need a CPA for this. In terms of attorneys, and I have no problem being pretty upfront with you about what I do. I do a lot of high net worth planning. So I work with people who need kind of advanced tax planning usually. So those kinds of attorneys, they're going to be a little bit more expensive, right? And a good attorney is going to be upfront with you. So if you came to me and I looked at your financial situation and I said, here's what I charge, I'm not the right fit for you. You want someone who's going to be honest with you, upfront with you. Get multiple opinions. Ask me. You can call me and you can say, I just had this meeting with this person, and I'll give you my off the record opinion about, this might not be a good fit, or this person is great. You're going to love working with them. I'm more than happy to do that. It's a small group of people who practice in this area, and we kind of know everybody. So don't be afraid to ask questions and ask for referrals and get a couple of different opinions. Most attorneys will chat with you at least for a couple of minutes. You say, hey, here's my situation. Here's what I've got going on. Here's what I need. Is this a good fit for you? What do you typically charge? Susanna, I see your comment. With respect to the healthcare power of attorney and the durable power of attorney, Rhode Island has statutory forms, so yes. I would not try to draft your own will or trust. That's my professional opinion on that, because I've seen some DIY wills before, and I can guarantee you pay more for them than that. But yes, durable powers of attorney and healthcare documents, absolutely, because Rhode Island has statutory forms that you can pull. Petra. And you are on mute.
Yes, just
Hi.
trying to maneuver iPad and that whole thing.
Yeah.
So thank you. This has been really very enlightening. I'm just curious in regards to revocable trust, how one would think about that. At what point, outside of the privacy, I didn't know that about wills, but just removing that factor, why would you, what is the driving force or the deciding factor to implement a revocable trust?
So I'd say that honestly, and this is maybe a crass expression, the more bang for your buck you get with a revocable trust it's tax planning. So if you are in a position where if you're married, there are ways that we can structure your trust. Let's say you and your spouse have over like 3.5 million or so. You each have more than that 1.6 million I talked about. There's ways to set up your trust to maximize the amount that goes down to your beneficiaries in a way that you can't do with just a will or joint ownership or beneficiary designation planning. You can't be as tax efficient. And trust me, I would be happy to talk to you ad nauseum about like how the mechanics work, but that's when everybody, it's 6:30, that's when everyone dies. They say, what did I sign up? Can I just go? So again, I'm more than happy to answer those questions if people have an appetite for it, but I'm also happy to back off on that one. Another reason, let's say you have a long-term trust. Some people will set up long-term trusts. So they say, not only do I want this to be in trust for my children's lifetime, then my grandchildren's, then my great-grandchildren's. It makes more sense logistically to have that in a separate revocable trust, because the probate court still has jurisdiction over trusts within a will. You can set up a trust in a will. I don't like to do it because of the probate court involvement. It's not huge. It's not as much as it used to be before there were some law overhauls, but I don't like it. Like, let's say there's a trust in that's benefiting my son for his lifetime. I don't want the probate court to be involved in that. If I have a little trust for him in the will, say, I'm giving this to my son, but until he's 21, pay it to him when he's 21, hold it in, a trust for, let's say he's 18, hold it in a trust for a couple of years, and then it's done. That's okay. I think that makes sense to have it in a will, but if it's a longer term thing, I don't want the probate court to be involved. So that's when I say you want to think about it. Same thing, special needs trusts. I prefer to see those in a separate revocable trust. You can even set up a standalone special needs trust for a beneficiary. Those ones you definitely want to have a lawyer involved, because there are ways that you can jeopardize their benefits. Let's say you want to do something good for someone who's got a long-term disability or and is on government benefits. It's great. We want you to benefit. Those people should have extra resources beyond what the government gives them, but we want to structure in a way that the government doesn't look at it and say, you have way more money than you used to. We're not giving you any more benefits. These are great questions. Now, are there any other questions? I'm more than happy to answer anything, chat about anything. I can talk about taxes for another hour and a half, right?
Just a really quick follow-up
Yeah,
on
you can.
Susanna's point. I didn't realize that I didn't need an attorney for the healthcare power of attorney and durable power of attorney. Do I just download those somewhere online or just Google it?
Susan, are you already working with an attorney?
I am, but for our forms, but I still need to do it for the kids' forms. So
Yeah,
if I don't need to go back to the attorney, that would be nice.
You can ask the attorney, if you're still working with the attorney, ask them like, how much would it be to just add on my kids' stuff? Because I'll be very frank with you, those documents are very cheap for me to draft as an attorney. So if you're already doing a will or a trust, it's really inexpensive usually to add on those documents. And I'd say if you were, let's say you came to me, Susan, and you were like, I only want to do a will and a trust. I'd say, okay, here's the price. And you said, now I want to do a power of attorney and a healthcare power of attorney. I'd say it's the same price. So that's just kind of a frank conversation. So if you're already working with an attorney, definitely have them review it. I don't know if I have I can look up the link for the healthcare power of attorney though.
Okay.
See if we
I'll
can
find
find
it too. Thanks.
Yeah, the healthcare power of attorney, I'd say definitely you can do it online. Durable power of attorney, I mean, as someone who has seen a lot of issues with banks, you might want to have your attorney review it. That's my professional opinion. Let's see, Rhode Island. Sorry, I'm loading the form for everybody. Oh yeah, this is what we do.
So it sounds like we might be coming to a bit of a close here, and Claire and I can, wait after we turn off the formal recording here, if anybody has anything else that they'd like to say. I would just note that October is National Plan Giving Month. This is actually National Estates and Planning Week. So it's a good time to be thinking about your will and estate, however big or small it might be. I popped into the chat a link to our webpage on planned giving, and there's a bunch of different tools here. We have a simple will writing workbook, which is meant to just help guide you and help you think about the kinds of questions that Claire was talking about. Who would you want in your family to do X, Y, and Z? And what kind of assets do you have? And then you can use this tool. You can either take it to a lawyer and talk with them about what you've thought about, or perhaps you can do something, working with somebody who's in planned giving generally. But I just wanted to note that that's a free resource that's on our website. There's also, for those of you who are 72 and a half or older, not that I think that anybody here is, but you also have an opportunity to do an IRA rollover and benefit a nonprofit with your gift instead of taking tax implications for the year. And so again, there's a little bit of information about that on our website. I'm going to turn off the formal recording here and just say thank you, all of you, for taking some time to think about your financial future. And then